what they want, or hearing what they want, what he can do and how he's going to do it, drawing a diagram, sending them away, and then inviting them to come back and discuss their treatment plan, and then we go forward from there. That dentist, to my knowledge, has never had an insurance claim, and he's never had a complaint yet either. So there is some method in spending time with patients, talking to them, letting them know what they're up for, and explaining things in great detail. He used to have a whiteboard in his surgery, because I've actually been to it, and he draws the teeth and all those sorts of things, and he hands out those MyTech brochures which you can get through the ADA bookshop. They may not be a panacea for everything, but they certainly help patients to go away and think about what they've been told. Okay, you saw from the HQCC, 1/3 of complaints are about communication issues, about rudeness, about arrogance. And if you're in private practice, I can assure you, patients generally don't know the dentist by name. All they consider it is that practice. And same goes for staff. They don't distinguish between the staff and the practice. It is that place. And of course, nobody's perfect, but when things go wrong, they expect it to be treated. I guess if you apply the rule that treat people as you wish to be treated yourself, that's a pretty good starter for any health professional, and particularly for dentistry. So, in the insurance world, what constitutes a claim? Basically, it is a notice of a demand for compensation. I want X amount out of you for pain and suffering. It is not, I want my money back. That's not a claim, but it may end up in being a claim, but we can deal with those issues separately. If you get a writ or a notice of claim or a solicitor's letter saying we put you on notice, within 28 days you'll get a formal claim. Don't sit on it, don't put it in the bottom drawer. You need to do something about it. And if you're insured with ADAQ or a member of ADAQ, then you need to tell me about it. You may also get a notice of an official investigation or inquiry, such as from APRA or from the Dental Board. Again, that if legal advice is required to provide a response, then we can arrange that, and that's covered under insurance policies. So, the claims in Queensland are basically covered by this piece of legislation, the Personal Injuries Proceedings Act, which has been around now for about 10 years, or effectively for 9 or so, I guess. But it does put a limit on damages on claims. And basically it says if it's 9 months past the date when you knew about it, then it's too late. Now, I can think of at least 2 claims in the last 2 years where that has been waived. They've gone to a magistrate's court and got an extension, and complaints that are several years old have been picked up. So you're not home free if it's 9 months, basically. And certainly 1 month after consulting a solicitor, well, how are you going to know that unless the solicitor tells you? You just simply don't. The process requires that all records, reports, x-rays and other material must be exchanged and provided to the claimant solicitor. The good thing about it is there is a mandatory, compulsory, whatever term you like to use, conference before anybody can go to court. And even after that, there's 60 days cooling off period when formal offers have to be put on the table. Now, I've been to several of these mandatory settlement conferences where we got to a stage where it was basically an impasse, and they bring their lawyers along and we take our lawyers along, and it's lawyers across the table arguing, finger pointing, shouting. No, there's no shouting, never been any shouting. I've had dentists come along to those at their own request. I personally don't think it's a good idea, but I've represented our members on many occasions, and we've managed to settle all but one across the table by doing so. And the one we haven't settled is still going. We're in the process of a cooling off period, and I'm pretty confident we'll get a result. This legislation, importantly, allows an expression of regret. Sorry is not an admission of liability. That's important. There are a lot of dentists around, particularly elderly ones. Ones who've been practicing for many years. Shouldn't use the term elderly with my hair. But there is a myth going around that saying you're sorry means you're liable. That's not the case. It's how you say it. So, you can say, I'm sorry. It's very unfortunate this happened to you. It's extremely unusual. Terribly sorry. Now let's see what we can do about it. But you just don't say, whoops, I made a mistake. Gee, that was my fault. Whatever. Reality is, as you could see by the number of claims that were settled without going to court, 97%. and 50% settled by just some argy-bargy. 50% not just resolved because they went away. Basically, people don't sue someone they like. Not all the time, but pretty much that's the case. If you have empathy with the patient, they trust you, they will allow you to fix the problem. But you have to, by the same token, the onus is then on you to know your limitations and don't go beyond them, because that's when trouble arises. And our statistics show that only about 1 in 8 people actually bother to make a complaint which ends up in a claim. So there you go. I might break now and ask Brad to talk about 2 very important issues, because this sort of thing is key. Getting consent for issues is a problem. It causes lots of heartache. It arises in all sorts of complaint issues and claims issues. And your records are your defence. They're very important. So over to you for a few minutes, Brad.
I'm basically because I can't see the people in the other places leaving when I get up to talk. I'll have to get my presentation up. Are there any questions for Paul from that? Because universities design these lecture theatres to stifle any possible feedback or enjoyment all in the world, not just here. But is there any questions for Paul while I'm getting this presentation? No? Okay, tough crowd. I'm just trying to find mine. Right, go back to the beginning. So, Bob, how much time do you want us to spend? Because we can do as much or as little as you like, and I know little's better than too much, but... Okay, that's fine. Okay, that looks much better up there than it does on my screen. So I'm going to just go through this in the sense of covering these 3 topics. So negligence is part of this for the students. So how many people in the audience are students? A few of you, so it's probably worth it for that. Is Ingrid Blomberg in the audience? No, Anne just told me she was going to come. Oh, well. Yeah, always the case. So this is basically what we, it's what Paul and I are talking about, but there's a bit on negligence as well, so it's probably worth quickly talking about that, although I've got the slides sort of talk about consent first. So consent is something that people don't understand very well, and I'm not going to give you a lawyer's definition of consent. I'm going to give you a dental practitioner's definition of how to talk about consent. People at the HQCC and other regulatory bodies talk about consenting people as if it's a sort of an active verb. I guess it's probably one of those words that's slipping into the way that we speak, but we don't talk about consenting people, but if you do deal with people in Queensland Health and other areas, they probably will talk about consenting. What they're meaning is trying to obtain valid consent. So consent in its broadest sense means you're giving people permission that they are informed to do whatever they're consenting to. So if someone comes and sits in a dental chair, they're consenting to some things. They're consenting to probably having their tooth examined or teeth examined or head examined, but they're probably not consenting to 4 implants on the lower jaw. So there's some implied consent by what people do, but you need more defined and explicit consent for the more complicated procedures you do. So some of the things you need to think about with consent is the first thing is capacity. So you cannot consent to something if you don't have the intellectual or other capacity to do that. So the biggest example of capacity issues in dental practice would be what? Does anyone? It'll be a lot quicker if people answer these questions. Did someone say children? Yeah, well children that's good. Children will do for a start. Children are the one that arise most frequently, and we get these discussions about can a 17-and-a-half-year-old give consent to dental treatment because they're not quite 18, and therefore can they give consent? And there's a whole string of cases which I won't bore you with because I can't remember them, but they relate to the person's personal circumstances. So if you take nothing away from the whole of this discussion tonight, is as a dental practitioner treating people, you have to advert to each individual's personal circumstances. You can't, dentists like to have a black and white rule, like if I do this, this is fine, if I do that, it's not. That's not how the world works. So if you're treating a patient who comes in and they're in a school uniform and they come in without their parents. They normally come with their parents, and you decide whether you're going to take radiographs or not. It would behove you to get parental permission in those circumstances. However, if a 16-year-old comes in with one child on a hip and another one on a hand, and it's a second child and she's never seen a mother for 20 years, do you need to ring the mother and get consent? No. So people need to advert, and some of this is common sense, but as I say, I don't know why they call it common sense, because it's not that common. There is no black and white rule about consent and age. You have to use your professional judgment. The other thing about consent is the personality of the person that you're dealing with, and some people will want to have every last detail spelled out to them. So two groups of people commonly want everything spelled out to them. Three, I should say, from my experience. Lawyers, engineers and dentists want to know the detail of everything. Most normal people and school teachers fall. It's like the Spanish Inquisition. Some of you don't remember what I'm talking about. Some of you have seen Monty Python. The four most common things are those groups. So when people... you have to advert to people's circumstances, and some people want to know all the details. Some people won't read a brochure, some people will read it in detail. So one of the things I'll suggest to you as we go through the actual process is making sure that people are exhausted. They have their options and their questions exhausted to where they're satisfied that they've got all the information they want. Now, for some people, if it was me, it'd be, you know best, just do it, and when can I get out of there? That's my personality and what I would do. Other people will need 4 or 5 or 6 visits and maybe 3 years before they'll consent to some particular treatment being done, and there's nothing wrong with that. That's just how people are. Occupations I've covered, but some people are more inclined to want to know the details. So if you've got someone who's a plaintiff lawyer, you probably want to have a better consent procedure than you have for someone who's, well, not. And guardianship and parenting, to some extent we've covered that, but guardianship is an issue whereby someone doesn't have capacity, whether it's through mental or other circumstances, and you have to get consent from a guardian, and there's all sorts of, we're not going to go into all of that tonight, but hopefully you get some instruction in the public guardian, the adult guardian, and just the principles of having someone to look after them. And often if you work with intellectually disabled children, when I was in Gibby for many years, Endeavour Foundation had a very large facility, and we had a lot of Endeavour Foundation kids and adults, so we had to be aware of this. But here's a question for you which no one's going to answer, but I'll ask it anyway. If this is a common problem for orthodontists, do we have any orthodontists in the audience? I thought it was just going to be dentists. Okay. It's a joke? No? Okay. It really is a tough crowd, isn't it? Okay. So orthodontists would often have this issue where a patient will come in and there'll be a dispute because the parents have, and this is something I personally like, is family breakup. And then there's lots of dispute about who's making the decision. So you'll have a parent who will not want to pay for the braces. Anyone, hopefully some of the orthodontists are going to nod here, and one parent who does. And I'm joking when I say encourage it. It's terrible, but it's great for family law practice because you'll never get broken with greed and lust, and that's what family law is all about. So when you have these situations where, well, it's property or money, I don't know what else, are children, that's all there is to it. When you have people that are disputing guardianship and the right to make a decision, you have to use common sense. And I'm not suggesting to you that you ring each family law solicitor and ask what's going on. What you might do, though, is find out what would be a hint as to who's got the primary right of control in those circumstances by asking the parents one question. And what might that be? Who is a responsible parent, who has a parenting order, who looks after them, who they live with most of the time. It can be difficult in some circumstances, but that's a guide. So you don't want to get caught out in those things because it can be difficult if someone gets banded up or someone has a tooth out because a parent says to take the tooth out and the other parent has an opportunity to be involved. It can be problematic. And basically it's a relationship with a patient. So the newer a patient is in your practice, the more time you need to understand them and get their valid consent. If a patient has been coming to you for 20 years and you know each other really well, you still need to explain the procedures, but you don't need to go into the detail that you would with a new patient. Which brings us back to the point of why new patients, people in practice who gets lots of new patients have a harder time, because really they have very high expectations and there's no relationship. And if you've got high expectations and no relationship, and an underperformance, then you've got a real problem. So that's the sort of background of consent without going to legality and boring you on witless. You have to consider the risk factors of each particular patient. So what we've got to at this point is we've got, I don't know which of these is your call, I've got Carlos. Okay. You need to consider the risk factors with each patient. So initially you've just considered the patient as a general rule, and now we're going to go to the particular risks. So the risks of the procedure this relates to. So the more permanent the risk of the procedure, the more consent that you should gain, or the more valid consent. So what's a permanent disability or injury that can result from dental practice? And I'll give you a hint, it's got very little to do with orthodontics. Actually, that's not quite true. But what would you say? Extractions of what? Wisdom teeth. It's much easier to talk about those things that we understand so well. So if someone's having a wisdom tooth out and they've got a permanent risk of paresthesia in the inferior dental nerve, that is important, isn't it? You would think so. Because what? Because it's what? Can be permanent. And if it's permanent, then it can't be reversed. And if it can't be reversed, then the only solution is to do what? Pay money, because that's all the law can do. All the law can do is withhold liberties from doing things or make someone pay money. I mean, I don't think there's anything else from that. That's about all that can happen. So you can't get a court order to repair the nerve, so you have to get money paid, and that's what insurers are all about. So the more permanent an injury, the more carefully you should consider the consent that you gain from that patient. The elective nature of the procedure is really important. The more elective the procedure, the court has held in a number of cases, but most famously Rogers and Whittaker in 1992, that the more elective the procedure, the greater the consent has to be, and the more the informed the consent should be. So does anyone know about Rogers and Whittaker? I'm sure some of us are as old as me do, but basically a woman went in to have some eye surgery. It was elective. The doctors were warned about sympathetic ophthalmia, and she went blind in her good eye, lost sight in both eyes permanently as a result of basically a cosmetic elective procedure. So that was in 1992, and that changed how consent is dealt with when we deal about warnings of risks in terms of procedures. The cost is another factor. So the more something costs, the more that you should, and Paul's already touched on that. So if someone's coming in having a scale and clean every year for $175 or thereabouts, you don't have to get consent to a great extent. However, if someone's coming in and having a dental implant placed on the lower, the mandible in the 6-7 region, then you probably need to get a different form of consent than what you would do. I'm exaggerating to make a point, but hopefully you understand what I mean. And the cost is greater. The higher the cost, the lower the trust, the more the risk. So if you've got a new patient with an expensive procedure who you don't know, then the risk is very high. I've spoken many times, and Paul and I have spoken, and other people in the ADA have spoken about a risk profile for dentists, so that if I'm just a dentist who goes like I have been my whole life and just goes and does crowns, a bit of restorative, a few extractions, but I don't do impacted wisdom teeth, I don't do implants, and I don't do cosmetics, then should I pay the same premium for my indemnity as someone who does all of those things? What do you think? Do you think it's fair that the same rate's paid? The reason that doesn't happen, even though it would make sense to, is that the competition for insurance across the country is in a national system, which we would like to see. It's state by state, so that if you start introducing higher premiums, the risky practitioners, they'll gravitate to other insurers, and then market share will be lost. But I'd like to think that one day we will have, I don't think Paul and I will live long enough, a national insurance scheme so that those issues are taken out of the equation. And special factors, and that can be a whole bunch of special factors in relation to patients' preponderance to sue, patients' general difficulty to get along with them, a whole range of things that might advert you to that patient's particular circumstances. So once we've got that, we start the actual process of getting consent from a person. So these next 5 or 6 points, 7 points, just joking, 5 or 6 points, relate to how you would do that. So the first thing you have to do is you have to explain the general nature and costs of the procedure to the patient. So you will know what an endosseous implant fixture is, I presume. Do you think a patient knows what an implant fixture is? Do you think a patient knows that an implant is made up of 3 to 4 components, and each of those is a different part? People think an implant is an implant. You have to explain the nature and you have to give people costs. And I actually disagree with Paul. Paul and I don't disagree on many things, but I would say as a practitioner you should give a written estimate for every single procedure you do for every patient. Every patient should not leave without knowing upfront what the cost's going to be. If it's not in writing, it doesn't exist. So that's we've got computer software these days. I don't know if you've seen computers. They're like this, except they're in dental practices. And the software is incredibly inexpensive, and the ability in a workflow to process that information and give everyone a written estimate is just so easy, it's ridiculous. So, yes. Is that a question or are you stretching?